A federal courtroom just witnessed something that hasn't happened in modern American history. Donald Trump now faces criminal contempt charges after a hearing that left seasoned attorneys questioning what they'd just seen unfold. We're not talking about campaign rhetoric or political theater here. A judge with 3 decades on the bench has put Trump's name on a criminal referral. And the language used in that referral should alarm anyone who understands how rarely this happens. When you hear a federal judge describe someone's actions as willful defiance in official court records, and you're watching something fundamentally different from normal legal proceedings, make sure you're subscribed, because what's developing here changes everything we thought we knew about presidential. Accountability. The catalyst came during what everyone expected to be a mundane procedural hearing on January 15th, and Trump was supposed to hand over financial records. Instead, he allegedly ignored a direct command from the bench and then went on what witnesses are calling an unprecedented verbal attack against the judge's credibility. Multiple lawyers in that room had never seen anything comparable in their entire careers. This transcends typical courtroom conflict. Word is spreading that members of Trump's own legal team are privately discussing whether they can ethically continue representing him, when the people being paid to defend you start looking for the door. You've crossed into territory that should terrify anyone in your position. Let me walk you through how this situation actually developed. The Manhattan Federal Courthouse has been a pressure cooker for months now, with constant battles over evidence deadlines, discovery fights, and increasingly bitter confrontations between Trump's lawyers and Judge Arthur Brennan. Everything reached a breaking point when court reconvened on January 15th. For what? The docket listed as a routine check-in about document submission. The session was supposed to start at 9:30 in the morning in courtroom 14B, according to the official court transcript. By 10:47, Judge Brennan had transmitted a formal criminal contempt referral directly to the U.S. Attorney's Office for the Southern District of New York. Do the math on that timeline. 77 minutes elapsed between opening statements and a criminal referral against someone who once held the highest office in the nation. That's how fast this exploded. The documents at the center of this firestorm were financial records from the Trump organization spanning 2018 through 2022. The judge had already ordered these materials produced on 3 separate occasions over the previous 4 months. When Trump's defense counsel acknowledged the records still were in the court's possession, Judge Brennan directly demanded Trump himself explain the failure to comply. If you're following along with where this is headed, go ahead and hit that like button right now. Here's the moment everything went sideways. Judge Brennan posed a direct question to Trump about why he had failed to honor 3 consecutive court orders. What came next caught the entire courtroom off guard. People who were physically present say Trump stood up from where he was sitting at the defense table, completely ignoring his attorneys who were visibly trying to stop him, and started addressing the judge without going through his lawyers. And according to these eyewitnesses, Trump said something along the lines of having complied with anything reasonable, then claimed the documents the judge wanted don't actually exist in the form the court believes they do. Judge Brennan's reaction was swift and cutting. He told Trump in no uncertain terms that he needed to communicate through his legal counsel, and that he needed to answer the actual question posed, not some different question he preferred. So Trump didn't stop, though. He kept going, and multiple witnesses report his volume increased noticeably. He called the entire proceeding a sham, claimed everyone present knew it, and said the documents would only demonstrate his business success, which he suggested has somehow become criminalized under the current administration. And multiple sources describe what transpired immediately after that second outburst. On January 15th, right around 10:15 in the morning, after Trump's second unsolicited commentary from the defense table, Judge Brennan announced a 15-minute break. People familiar with what happened during that recess told CNN that Trump's lead attorney, Christopher Keese, was observed in what appeared to be an intense disagreement with his client inside a private conference room adjacent to the courtroom. Security officers stationed nearby reported hearing elevated voices coming through the closed door, and when everyone returned to the courtroom and proceedings started again, Keese tried apologizing for his client's behavior and asked for a short delay to gather the outstanding documents. The judge refused the request. What unfolded next has been characterized by veteran court journalists as the most stunning judicial confrontation they've witnessed in their professional lives. Judge Brennan spoke directly to Trump, and appearing to read from notes had already prepared, and stated that following 3 separate orders for document production, following explicit warnings about what would happen if compliance didn't occur, and following the behavior displayed in the courtroom that day, the court had reached an unavoidable conclusion that Trump had engaged in willful contempt. Drop your thoughts in the comments section right now, because I actually read every single one you leave. Now, we're getting to the truly explosive part. The moment Judge Brennan announced he was filing a formal criminal contempt referral, the entire courtroom went silent. Reporters sitting in the gallery say all color drained from Trump's face's hands, which had been moving expressively throughout his earlier statements, fell motionless to his sides. Keese jumped up to register an objection, but the judge immediately cut him off before he could get a full sentence out. He told the attorney that Trump had received every possible opportunity to comply with the court's orders, that those opportunities had been exhausted, and that the time for objections had expired. The moment that will define this hearing came when Judge Brennan read the exact wording of his referral into the official record. He stated that the court was formally referring Donald J. Trump to the United States Attorney for the Southern District of New York for criminal prosecution under Title 18 United States Code Section 401 for contempt of court, along with potential charges under Section 1503 for obstruction of justice. The judge went on to say that evidence presented to the court demonstrated a clear pattern of deliberate defiance against lawful court orders that civil sanctions alone could not adequately address. That specific phrase matters more than you might realize. When a federal judge explicitly states that civil sanctions alone are insufficient, he's declaring that the defendant's conduct has become so severe that only criminal prosecution can serve as an appropriate response. Any claims about a weaponized justice system fall apart when you realize the judge making this referral was appointed by George H.W. Bush, a Republican, and has maintained a 30-year track record of measured, nonpartisan decisions from the bench. Presidential defiance of court orders isn't completely without historical precedent. Consider Richard Nixon and what became known as the Saturday Night Massacre back in October 1973, when Nixon directed the termination of Special Prosecutor Archibald Cox to block the release of White House tape recordings. Nixon wasn't held in contempt, but public reaction was so intense it accelerated his trajectory toward resignation, and the underlying pattern was identical then to what we're seeing now: obstruction compounded by additional obstruction, compounded by unavoidable consequences. Then there's Bill Clinton's contempt citation in 1999. Judge Susan Weber Wright held Clinton in civil contempt for providing false testimony during the Paula Jones case and imposed a fine exceeding $90,000. But here's what makes that situation fundamentally different from this one. Clinton faced civil contempt, not criminal. The outcome was a monetary penalty and temporary suspension of his law license. What Trump is staring down is an entirely different category of legal jeopardy. Criminal contempt comes with the possibility of imprisonment. If you haven't subscribed yet, do it immediately because you won't find this analysis anywhere else. We also can't ignore Trump's own documented history with judicial authority. During the New York Attorney General's civil fraud case last year, Judge Arthur Engoron fined Trump more than $5,000 for violating a gag order, then escalated the penalty to $10,000 per violation when the behavior persisted. And the pattern repeats itself consistently. Courts issue orders. Trump treats them like suggestions. Warnings get issued. Trump escalates his behavior. Now, after years of this same conduct across multiple different jurisdictions, a federal judge has finally declared that enough is enough. So what actually triggered this unprecedented criminal referral? Legal experts who've examined the public court filings and official transcripts say Trump's conduct violated multiple core principles of judicial procedure. First, the repeated refusal to produce subpoenaed documents following 3 direct orders established an unmistakable pattern of defiance. Second, the courtroom outburst where he spoke directly to the judge against his counsel's guidance and attacked the legitimacy of the proceedings constituted what Judge Brennan characterized as fundamental disrespect for the authority of this court. Third, and this is the most damaging element, prosecutors disclosed that certain documents Trump claimed were non-existent were later located on Trump Organization servers by a court-appointed special master. This wasn't merely failure to comply. According to the judge's ruling, it constituted deliberate concealment combined with false representations to this court. Here's what should really get your attention. The documents that were ultimately discovered contained internal property valuations from the Trump Organization that directly contradicted sworn statements Trump had previously made in other legal proceedings. This wasn't some minor discrepancy. Based on filings that became public on January 16th, the internal valuations for Mar-a-Lago alone showed a difference of more than $400 million compared to public representations. When you claim documents don't exist, then those exact documents surface and prove you made false statements under oath. Your criminal exposure doesn't just increase, it multiplies exponentially. And stay right here because the most explosive segment is coming up next. Here's what should concern everyone paying attention. This isn't confined to one contempt referral or one set of missing documents. If a former president can repeatedly ignore court orders, verbally attack judges in official proceedings, and face no meaningful consequences, the entire foundation that judicial authority rests on starts to collapse. The ramifications extend far beyond Trump as an individual. Every defendant standing before every judge in every courtroom across America will reference this case and question why they should comply when a former president wasn't required to. And once that precedent gets established, there's no mechanism to reverse it. The situation creates an exceptionally difficult position for Republicans. On one side, they're facing pressure from a base that interprets any legal action against Trump as political persecution and demands unconditional support regardless of what the evidence shows. That means defending conduct that any first-year law student would immediately recognize as contempt, attacking the judge as politically biased despite his Republican appointment and asserting that the entire justice system has been weaponized against their candidate. On the other side, they're confronted with a federal judge's comprehensive findings documenting willful defiance, document concealment, and false statements made to the court. They need to explain to voters why basic legal compliance shouldn't apply to the candidate they support. There's no viable middle position here. Either the judge, a 30-year veteran who was appointed by a Republican president, is lying and corrupt, or Trump did exactly what the referral documents say he did. Legal analysts and political observers are characterizing this as a potential inflection point. Sarah Isgur, a former federal prosecutor and CNN legal analyst, told the network that criminal contempt referrals targeting high-profile defendants are extraordinarily rare because judges fully understand the gravity of taking such a step. She pointed out that Judge Brennan's extensive written findings suggest he anticipated intense scrutiny of this referral and wanted to create an unassailable record. Laurence Tribe, the Harvard law professor and constitutional scholar, posted on social media that Trump's courtroom behavior, as documented in the transcript, represents perhaps the most brazen defiance of judicial authority by any president or former president in American history. He emphasized that the combination of document concealment and direct attacks on judicial legitimacy provides prosecutors with an exceptionally strong case. Do me a favor and hit that like button, because it genuinely helps this video reach more people who need to see it. Even Jonathan Turley, the George Washington University law professor who frequently defends expansive presidential authority and has provided testimony supporting Trump in congressional hearings, acknowledged that the referral creates substantial legal exposure. He stated on Fox News that while he has reservations about the broader prosecution strategy targeting Trump, the specific contempt findings are challenging to dismiss. If documents were genuinely concealed following court orders, that constitutes a serious problem regardless of anyone's political perspective. Let me break down what this could actually mean going forward. First, the immediate legal consequences are severe. A criminal contempt referral means the U.S. Attorney's Office must now determine whether to convene a grand jury and pursue an indictment. Given the detailed findings already entered into the official record, legal experts are saying that declining to prosecute would require extraordinary justification. The standard timeline for such a determination is typically 60 to 90 days, which means we could see movement by late March or early April. Second, this creates devastating complications for Trump's other ongoing legal battles. He's currently facing criminal charges across 4 separate jurisdictions, dealing with civil fraud judgments that total more than $400 million. And now has a criminal contempt referral that paints a picture of systematic defiance toward legal authority. Prosecutors in Georgia, Florida, and Washington, D.C. are undoubtedly paying close attention. Judges presiding over those cases will be even less tolerant of any behavior resembling what occurred in New York. Finally, the political implications for the 2024 campaign are substantial. A criminal contempt indictment, if one comes, would make Trump a defendant in 5 separate criminal cases simultaneously. Every single campaign event would be overshadowed by questions about his willingness to follow basic court orders. The image of a presidential candidate who attacks judges and defies their rulings is one thing when it exists as campaign rhetoric. It becomes something entirely different when there's a formal criminal referral documenting precisely that behavior. Drop a comment below sharing your perspective, because I am genuinely interested in what you think about all this. Beyond the immediate legal and political fallout, this really concerns something foundational to our constitutional system. The courts represent the institution Americans depend on to enforce the rule of law equally, without regard to wealth, power, or political position. So the principle that no one stands above the law isn't just campaign language. It's the foundational premise that gives judicial authority any meaning at all. If a former president can defy court orders, conceal documents, attack judges in official proceedings, and face no consequences, that principle becomes empty words. The courts transform into advisory bodies whose rulings only apply to people who lack the power to resist them. This scenario is generating something approaching panic inside Republican leadership circles. Reports indicate that senior party officials convened an emergency conference call on January 16th, the morning after the contempt referral became public knowledge. According to sources familiar with that discussion, some participants argued for aggressive defense, framing the referral as yet another example of prosecutorial overreach, targeting their likely nominee. Others voiced deep concern that defending open defiance of court orders would alienate moderate voters and suburban women who had already moved away from the party. The conversation reportedly became heated, with no consensus emerging on messaging strategy. Meanwhile, Trump's core supporters are mobilizing in predictable fashion. Social media platforms are flooded with attacks against Judge Brennan. Assertions that the documents in question were planted as evidence, and claims that the entire judicial system has been corrupted. Fundraising emails distributed within hours of the referral reportedly generated more than $2 million using language like "they're trying to jail me for fighting for you." The situation escalated further when Trump himself responded on Truth Social at 11:47 p.m. on January 15th, just hours after the contempt referral, He labeled Judge Brennan a radical left activist, despite the judge's appointment by George H.W. Bush, claimed the referral was coordinated with Biden's Department of Justice to interfere in the election, and described the missing documents as a complete fabrication by corrupt prosecutors. He concluded with language that legal experts immediately flagged as potentially problematic. Stating this, so-called judge will learn that he can't push around a future president and that there will be consequences. Stay with me because what happens next will completely transform how you understand this situation. Here's what makes that response even more remarkable. Instead of showing any regret, any willingness to comply moving forward, any acknowledgement that defying court orders carries consequences, Trump doubled down with what reads unmistakably like a threat directed at a sitting federal judge. Legal experts immediately noted that statements like this could be introduced as evidence of continuing contempt, a factor that would carry significant weight in any prosecution decision. And when your defense against a contempt charge consists of attacking the judge and promising consequences, you've essentially validated the court's characterization of your attitude toward judicial authority. Andrew Weissman, the former FBI General Counsel and Department of Justice prosecutor, posted that Trump's response functioned as Exhibit A for prosecutors attempting to establish the willful nature of his contempt. He observed that defendants hoping to avoid criminal contempt charges typically express remorse and commit to future compliance. Trump did the exact opposite. This transcends a single contempt referral or a single federal judge. The question is whether the judicial system possesses any meaningful authority over individuals with political power. If Trump's behavior produces no consequences, every defendant in America will have grounds to demand equal treatment. How can any judge hold anyone in contempt when a former president engaged in identical conduct and walked away? The precedent would be catastrophic for the administration of justice at every level. If there are no consequences, it establishes a dangerous message that courts are performative institutions whose rulings can be ignored by anyone willing to accept the political cost of defiance. This isn't just about this particular case. It's about whether judicial authority itself retains any meaning when confronted with sufficient political power. If this is blowing your mind, hit that like button right now. Here's where we stand. A federal judge has formally referred Donald Trump for criminal prosecution based on repeated defiance of court orders, concealment of subpoena documents, and courtroom conduct the judge characterized as deliberate disrespect for judicial. And legal experts across the political spectrum are acknowledging that the referral is thoroughly documented and difficult to dismiss. Meanwhile, Trump's response has been to attack the judge, assert conspiracy, and issue what appears to be a threat of retaliation. When a Republican-appointed judge with 3 decades on the bench files a criminal referral against a former president, we've entered genuinely unprecedented territory. If no consequences follow, it establishes a dangerous precedent that will reverberate through our legal system for generations. Future presidents will understand that court orders are optional. Future defendants will demand identical treatment. The rule of law will only apply to those lacking the power to resist it. Keep close watch on this story. The U.S. Attorney's Office has up to 90 days to convene a grand jury and make a prosecution. Determination. Judge Brennan has scheduled a status conference for February 8th to address any remaining discovery issues, and Trump's legal team is reportedly considering an emergency appeal to the Second Circuit. Though legal experts emphasize that grounds for overturning a contempt referral are extremely narrow, Americans across the country are watching closely to see whether the courts can enforce their authority against the most powerful defendant they've ever confronted. Before we continue, hit that subscribe button so you never miss content like this. Here's the current state of affairs. A former president has been referred for criminal prosecution by a federal judge for willful contempt of court. His response was to attack the judge and promise consequences. His supporters are rallying to his defense. His opponents argue this confirms what they've always believed about his attitude toward the rule of law. And prosecutors in the Southern District of New York now face a decision that could define how history remembers this moment. This and another news cycle that will disappear. This is a stress test of judicial authority happening in real time. What happens next could determine whether court orders carry any weight when directed at individuals with political power, whether the rule of law is a principle or merely a convenience, whether the judicial branch can fulfill its constitutional function as a check on executive overreach. The evidence is in the official record. The referral has been filed. Now we wait to see if accountability still means anything in our system. The stakes have never been higher. The evidence has never been more clearly documented, and the constitutional crisis has never been more immediate.